Imagine knowing exactly when a trust helps and when a will is more than enough. That's what this video is all about. If you've ever wondered if you really need a trust in addition to having a will here in New Jersey, you're not alone. And it isn't about selling you a trust or scaring you about probate. It's about clarity. It's about helping you make the right decision for your situation because a lot of the advice you see online simply doesn't apply in New Jersey. Here's what you're going to learn in the video. First, how to tell whether a trust actually gives you real benefits in your situation, or if a properly drafted will would do the job just fine without extra cost or complexity under New Jersey law. Second, how a trust works during your lifetime, not just after death, and why trusts are usually more about control and continuity than avoiding probate. And third, how you weigh the real trade-offs, cost, effort, and responsibility, so you can decide if a trust is truly worth it for you or not. The goal here is informed decision making, not one-size-fits-all advice. Most people start this conversation with the wrong question. They ask, how do I avoid probate? When the better question is, what problem am I actually trying to solve? This is where the idea of control versus convenience really matters. Some estate planning tools are about convenience after death. Others are about control during life. Problems happen when someone picks a tool designed to solve one problem, thinking it solves the other. In New Jersey, probate is usually a matter of convenience. It's an administrative process handled through the county surrogate's court. Trusts, on the other hand, are usually about control. Who manages your assets, how they're managed, and when, especially if you become incapacitated. Once you understand the difference, the whole trust versus will conversation starts to make a lot more sense. So let's reframe the decision. Choosing between a trust and a will is not about good planning versus bad planning. It's about identifying the actual problem you're trying to solve. In New Jersey, probate generally involves validating a will, appointing an executor, and transferring assets through the surrogate's court. In uncontested cases, this process is typically straightforward and relatively inexpensive, no matter the size of the estate. So if probate itself isn't the real problem, avoiding it shouldn't be the reason you choose a trust. That leads to an important point. In many situations, a well-drafted will is more than enough. When a will is combined with proper beneficiary designations and smart ownership strategies, it can fully accomplish someone's goals. Many assets already pass outside of probate through beneficiary designations, joint ownership of certain assets like a bank account with right of survivorship, or payable on death accounts. In those cases, adding a trust may not provide much extra value. Choosing a will in those situations isn't cutting corners. It's choosing the right tool for the job. But there are many times when a trust really does become the better tool, and this is where trusts truly shine. A revocable living trust allows your assets to be managed seamlessly if you become incapacitated without the need for court involvement. That's very different from a will, which does nothing for you while you're alive. Powers of attorney can help, but they aren't always accepted, and sometimes they require extra steps or cause delays. For many people in New Jersey, this lifetime control and continuity is the strongest reason a trust makes sense. Not avoiding probate, but maintaining control if something happens to you. There are also other situations where a trust adds value. Privacy is one of them. Probate filings are public records, and some families prefer to keep financial details and beneficiary information private. Complexity is another factor. Blended families, staggered distributions, beneficiaries who need structure and asset protections from creditors or divorce, or estates that include real estate in more than one state, can all complicate administration. There are also instances where the estate is of such a size that tax planning may be important. In these cases, a trust can make things much smoother. But again, these are situational advantages, not universal requirements. It's also important to talk honestly about the downside. Creating and maintaining a trust usually costs more upfront than probating a will in New Jersey. And a trust only works if it's properly funded. If assets aren't actually transferred into the trust, like real estate, it can create a false sense of security. This is why the decision should be based on value, not fear. So let's come back to the right question going forward. The real question isn't, should everyone have a trust? The real question is, what do I want my estate plan to do while I'm alive, and how complex do I need it to be after I'm gone? When you frame it that way, the answer to when a trust is better than a will becomes much clearer. Now, if you're starting to see that a trust might be helpful in some cases, but not in others, there's a bigger picture you need to understand. A will and a trust are only pieces of something bigger. Many people assume a will is an estate plan. In reality, a will is just one document within a complete estate plan, which may also include trusts, powers of attorney, and healthcare directives. In the next video, titled, Is an Estate Plan the Same as a Will?, I break down what an estate plan really is, why a will alone is often not enough, and how all these documents are supposed to work together, whether or not a trust is part of the plan. Make sure you watch the next video so everything you just learned actually fits into the bigger picture.